Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Very recently, the Honorable Supreme Court of India, by disposing the SLP 9572 by 2022 on 17/10/22, that is yesterday. So, in the case of Union Territory of Jammu and Kashmir versus Wahid ur-Rahman, parra, Wahid ur-Rahman, parra. So, held that, please remember, bail orders should be crisp. Bail orders should be crisp and short. You will not elaborately give the bail order in hundreds of pages. It's not necessary. Of course, here the important point you have to learn is the Supreme Court did not want to interfere with the bail order. That means the bail which is given is existing. At the same time, they have remarked that the bail orders need not be too lengthy. This is what the Supreme Court opined. Justice Sanjay Kishan Kaur and Abhay Srinivas Vakha, they have orally said in a bail matter that bail orders should be crisp and short and should not exceed 2 or maximum 4 pages. So this is their opinion. So what do you call the oral observation? This is obiter dicta or passing remark. It is only their opinion. So it is not a guideline that the bail order should be only cut to only 2 or 3 pages. But in general, they have been telling that the bail order need not go into all the details. Only 4 aspects they have to take. What is the gravity of offense? Whether it is a murder for gain, or a murder with writing, all these things. Then, is there any threat to the witnesses? Is there any opinion that he can manage, the accuser can manage the witnesses? So, is there any threat to the life of the accused persons? So, taking these 4 points into view, the bail order will be given or not. Because you all know that giving bail is only the personal discretion of the judge. This is the general concept. Here what happened is, so actually this the Wahid ur-Rahman, parra, he is targeted, he was arrested under Unlawful Activities Prevention Act, UPA Act. The allegations are that he was engaging the terrorists, he even visited Pakistan, and Solicitor General Tushar Mehta, he has brought all these facts to the notice of the Honorable Court. But previously, Jammu and Kashmir High Court has given bail to Abdul Rahman. So therefore, against to the orders of the bail, the state of Union Territory of Jammu and Kashmir appealed before the Supreme Court. Now, Solicitor General Sri Tushar Mehta, he stated that this man is not very active. He was engaging terrorists. He has procured weapons like AK-47. So, he cannot be given bail. But please remember, the Honorable Supreme Court of India, the bench said that they won't give importance to the observations made by the High Court. Because the High Court has made so many observations. So the contentions have been answered, the contentions of the government has been answered by the Jammu and Kashmir High Court. But let us not go into the details. They are not at all necessary. And please remember, the Supreme Court declined to interfere in the bail application. Because in this connection, jocularly, Tushar Mehta sir also said, "Say, Your Honor, preparing an offence, that means preparing the grounds for UAPA itself is an offence. That means the people are bothered so much. They took so much of pain in preparing the offence also. But still, the court has given bail for such persons." So, the government has vehemently objected to the bail orders, but Supreme Court said they will not interfere. This is one part. But our point is, Supreme Court orally stated that bail orders need not be too lengthy. They did not. The High Court has gone into so many details, internal matter, so many importance, so many observations they have made, which are not important. Are you satisfied that it is a case worth to be given bail or not? That's all. If you satisfy, give bail. Then you impose certain conditions. That itself is sufficient. So Ultimately, to conclude, the Supreme Court said bail order should be crisp and short. Itself is enough. Okay, if you know this much, so please remember 2 points. Number one, obiter dicta, the bail order should be crisp and short. With this, I am concluding. Thank you very much.